Well, a happy election day for all of you out there. Hopefully by now you have all voted, and we all just want to be left alone and not have to see another ad from either candidate or being pressured to go vote and being bombarded with all these ads. I'm sure we all want to take a nice break from that. Well, here I am to give you that break. Just tune into Brother Counsel. We'll be able to explain and analyze some of the very interesting cases that are going on right now. So today we're going to be discussing the Sarah Boone motion for a new trial. And we all know that Sarah Boone was offered a sweetheart of a deal. I couldn't believe this deal was even being offered. 15 years. And she already served 4 years of that. So she was really looking at a sweetheart of a deal. Nevertheless, she rejected that deal, decided that she wants to take a chance at trial, getting completely acquitted. And as predicted by everybody else who was following this trial, she actually was convicted. And now she's facing life in prison. So therefore, she doesn't like that proposition. So she got her attorneys to file a motion for a new trial. So we're going to be breaking down that motion today. Eventually, the state's going to file a response. We, of course, are going to be doing some research on all these cases that they're citing in their motions and responses, and I'm going to be giving you my opinion whether there's any sort of basis or argument to be made with respect to this specific request for a new trial. Now, before we jump into the motion, I do want to make some very important announcements. Number one, tomorrow, November 6th at 9 a.m., the Massachusetts Supreme Court is going to be hearing oral argument on Karen Reed's double jeopardy claim. And we've already explained all of the law that governs double jeopardy as it relates to Karen Reed's situation. We've explained it in our previous videos. If you haven't seen that, definitely go check that out. But I will be there tomorrow with you live streaming it. I'm going to be live streaming it on my channel tomorrow, 9 a.m., the oral argument for Karen Reed. And I've done all the research. I know the law like the back of my hand, and I will be there with you, walking you through some of the oral argument and giving you my real-time analysis on perhaps some of the Supreme Court justices' questions. Everything that's going on tomorrow, I'm going to be giving you my real-time analysis. So definitely tune in tomorrow, 9 a.m., November 6th, Brother Counsel Studios live streaming the oral argument from the Massachusetts Supreme Court on Karen Reed's double jeopardy claim. All right. Number two is I want to give a shout out, of course, to the sponsor of this video, The Suit Depot, which is a wonderful store which has high quality suits and apparel for very reasonable prices. And my listeners, only my listeners, get a 10% off. If you are checking out of the Suit Depot, just type into the coupon box, Brother Counsel, all lowercase, no spaces, and you will get 10% off of your order. All right, with that being said, let's jump into the Sarah Boone motion for a new trial that was filed just yesterday at the end of business, close of business. So here we go. See, it gets 4:56 p.m. on November 4th. That's when this motion was filed. So here we go. Defendant's motion for a new trial comes now. The defendant, Sarah Boone, by and through counsel and pursuant to Rule 3.600, Florida Rules of Criminal Procedure, files this motion for a new trial, stating in support thereof the following. Number one, the defendant was found guilty as charged of second-degree murder on October 25th, 2024. The instant motion is timely, filed pursuant to Rule 3.600. Okay, motion is timely. That's important. Number three, the defendant asserts that she is entitled to a new trial under Rule 3.600 on the following grounds. So there's a few different grounds that they're going to be moving for a new trial. Number one, the court erred in ruling that the defendant was not entitled to court-appointed counsel. Number two, the court erred in denying undersigned's counsel multiple motions for continuance. Number three, the court erred in failing to grant a new trial when the alleged victim's family caused an emotional outburst in open court in the presence of the jury prior to deliberations. Number four, the trial court failed to disallow the opinion testimony of the state's rebuttal expert witness, Dr. Tonya Werner, MD, after the state failed to disclose before trial that the witness had formed a new opinion. And number five, the state committed prosecutorial misconduct by essentially making a second closing argument instead of a rebuttal argument. So here we go, going one at a time. The trial court erred in holding the defendant was not entitled to court-appointed counsel. In the above styled and numbered case, the defendant had approximately 7 court-appointed attorneys prior to the undersigned counsel taking her case. Undersigned counsel took on the above case because he was concerned that Ms. Boone would not have an attorney to represent her at trial. It wasn't for the fame or anything like that. The above case was very complex, even for a seasoned trial attorney who was the public defender of the First Judicial Circuit for years, as well as having a thriving private practice. That's referring to himself, James Owens. It was apparent to undersigned trial counsel that Ms. Boone would be grossly ill-prepared and unequipped to handle a trial in this matter, or in fact, to handle any other phase of the trial without counsel. Both the Sixth Amendment as well as Rule 3.111 Florida Rules of Criminal Procedure guarantee an indigent defendant the right to appointed counsel. See Bowden versus State and State versus Kelly and progeny. There appear to be two exceptions to this precedent. Number one, if the defendant physically harms or threatens to harm, meaning rape, battery, etc., his or her counsel. So that's number one reason why that a defendant may lose the right to appointed counsel. Well, that didn't happen in this case. And number two, if the trial court certifies that the defendant will not be incarcerated if found guilty, i.e. a judge trial. Should the court determine that the defendant is not entitled to court-appointed counsel due to misbehavior on the part of the defendant, the court must follow a process which protects the individual's right to due process as well as the defendant's right to the assistance of counsel. In the instant case, undersigned trial counsel would assert that Ms. Boone's behavior did not rise to the level of misconduct to warrant a waiver of the right to court-appointed counsel. And if the court determines that she waived her right to court-appointed counsel, then the court failed to warn her or inform her that continued misbehavior would result in a waiver of the right to court-appointed counsel. So here they're arguing two things. Number one, she did not misbehave in a way that warrants her waiver of court-appointed counsel. And number two, she wasn't warned about that. If you want to, as a judge, say that you've waived your right to court-appointed counsel, you have to warn the defendant. This is what their argument is. You have to warn the defendant that if you continue doing this, that's going to result in the waiver of court-appointed counsel. And they're arguing that never happened. That warning never happened. So two arguments under this prong. Under controlling precedents, failure of the court to appoint trial counsel can result in a motion for a new trial being granted. See Figueroa Sanabria versus State and Wilson versus State and progeny. Under controlling precedents Rule 3.111 Florida Rules of Criminal Procedure and the Sixth Amendment, the defendant through counsel moves the court for a new trial. So these are definitely cases that I am going to be looking up and seeing whether this actually is true, what they're representing. Because again, this is just argument. If they don't have any basis for their argument, then we just completely discredit it. But if these cases stand for some sort of proposition that what they're arguing here, that they have to be warned, or that what's considered misbehavior, then we have to see whether their argument holds any weight under the law. But we're going to get to that later. But let's just get through the motion first. Argument 2. The court erred in failing to grant defendant's motion for continuance made by undersigned trial counsel. The court shall not deprive a defendant of his or her right to counsel of their own choice. Failure of the trial court to grant a continuance will result in a new trial should the court deny said motion for continuance by new counsel. And they're stating a case here, Perosa versus State. So she has new counsel, and now the new counsel moved for a continuance. That was the first thing that James Owens did. And now they're arguing, well, since there's new counsel and we moved for a continuance and you did not grant it, that automatically should mean that we get a new trial. And that they're stating these cases, Perosa versus State, McKenzie versus State, Jones versus State, and Deal versus State. And again, they're not really giving any sort of analysis under those cases. They're not saying, well, those cases, this and this and this happened, and this was the ruling. So they're just kind of stating that that's what these cases stand for. And it's a little bit sloppy. I don't love the way that this brief, and again, you are stating some cases, but if you really want to have a strong brief, you show how this case mirrored the facts of this case, and that's why you should grant us this motion. You should grant this motion because that's what they did in these cases. But that wasn't done, so therefore they're going to make me do the work and look up these cases and then report back to you. So don't worry, I got some homework to do. In the instant case, when undersigned counsel came on board, the case was 4 years old. Undersigned counsel filed his notice of appearance on August 30th, 2024. This gave counsel 45 days to prepare for a second-degree murder trial. He immediately and aggressively began to prepare for trial. Undersigned counsel did his best to prepare for trial by traveling to Orlando from Milton on multiple occasions, both for meeting with Ms. Boone, and attending multiple hearings. Despite his best attempts to prepare for trial, it was impossible to adequately prepare for unforeseen issues arising during trial. A prime example of this would be reviewing hundreds of pages of texts from Ms. Boone's seized cell phone, viewing all records of prior contact of Ms. Boone and the alleged victim with law enforcement, including inadmissible hearsay by the alleged victim to law enforcement regarding Ms. Boone being the aggressor at times. Counsel, for all purposes, closed his law practice down to prepare for the trial, but due to the short time frame, even with the assistance of other attorneys, was simply logistically unable to be as prepared for trial as he would have liked to be, and as Ms. Boone was entitled to. Under the controlling cases cited supra, the court's failure to grant undersigned counsel's motions for continuance should result in a new trial. So again, these are all just allegations. These are arguments, but you've got to show them. You've got to show the judge how these cases, Perosa versus State, McKenzie versus State, Jones versus State, mirror this same situation, and therefore you have a right under this case law to ask what you're asking for. But they're not. They're just kind of like saying it like, oh yeah, just look at these cases. They all stand for this. I mean, I don't know. Now you're going to make the judge do it all? Judge's not going to be happy with that. All right, number 3. The court erred when it denied a motion for new trial due to an emotional outburst in the presence of the jury. Prior to jury deliberations, the alleged victim's family members began to audibly and visibly get upset and departed the courtroom. Undersigned counsel timely moved for a mistrial, requesting a new trial. The court did not give any curative instructions or address whether the outburst could adversely affect the jury's deliberations. Florida appellate courts have held that the failure of the court to grant a curative instruction or a mistrial can result in the necessity of granting a new trial. Now, that is a very broad statement, okay? That the fact that Florida appellate courts have held that the failure of a court to grant a curative instruction in what situation? You've got to say the situation in which the courts did not grant a curative instruction or did not grant a mistrial, which resulted in granting a new trial, and then show that in those situations, that's exactly similar to what happened here. Show a case. There was an outburst, and there was an outburst in that case. Maybe this is the case. Let's just, for example, say Nebergel versus State was a case where there was an outburst by a victim's family, and therefore the judge had to give a new instruction, and that's what the opinion says. But they don't do that, which is just very frustrating, especially if you're the judge on this case, to read this and know what these cases are actually talking about, and you're going to make the judge have to do all this research. He's not going to be so happy. The court is unable to determine if this outburst affected the jury's decision because no inquiry was made. Under controlling precedents, the defendant is entitled to a new trial. So again, just dumping this case law into a brief doesn't always help your cause. You got to do a little bit more work. You got to show how these cases have something to do with what you're asking for and how there's similar fact patterns. Again, I think a little bit sloppy. Well, let's continue. The court erred in allowing the opinion of the state's expert not previously disclosed. The trial court failed to disallow the opinion testimony of the state's rebuttal expert witness, Dr. Tonya Werner, MD, after the state failed to disclose before trial that the witness had formed a new opinion relating to whether the defendant perceived an imminent threat at the time of the offense. This issue was discussed extensively in the expert witness deposition taken on October 4th, 2024. The state committed prosecutorial misconduct by failing to disclose this new opinion as agreed in the deposition mentioned above. In addition, the state's expert opinion on whether the defendant perceived an imminent threat necessary for the justifiable use of force and battered spouse syndrome testified to before the jury was improper. So this expert opinion, the state's expert opinion, saying that the defendant really did not perceive an imminent threat, which would then justify the use of force, that testimony was improper. The state's expert, Dr. Tonya Werner, MD, admitted that she had not listened to the defendant's testimony before the jury before forming her opinion on this ultimate issue of fact. In addition, Dr. Werner failed to listen to the testimony of Dr. Michael Brannon and Dr. Julie Harper before expressing her opinion. Furthermore, the state's expert testimony on this issue of whether the defendant perceived an imminent threat at the time of the event violates the province of the jury. Witnesses are prevented from expressing their conclusions when the opinion only tells the jury how to decide the case and does not help the jury determine what occurred. Now, I can tell you right away, I don't know for sure if Florida is a jurisdiction like this. That's why I have to do some more research. But in many jurisdictions, an expert is actually allowed to give an opinion on an ultimate issue. So a lot of times what I find is that A lay witness is not allowed to give, a regular witness is not allowed to give an opinion about an ultimate issue, but sometimes experts are. So unless this case, Mutri versus Bethlehem Cookman University, says that an expert is not either allowed to, then I'm not sure, but they don't say exactly. When a witness is asked to express an opinion that applies a legal standard to a set of facts, the opinion testimony is generally inadmissible. Section 90.703 does not permit a witness to testify to legal conclusions or express an opinion upon questions of substantive law. The testimony may interfere with the function of the trial judge to determine the applicable law and to instruct the jury thereon. And again, another case for that. So again, not straight out where it says an expert witness, but they're just generally talking about witnesses in general. But again, it needs a little bit more research in order to really come to that conclusion. Argument number 5. The prosecutor committed misconduct by using rebuttal argument to make a second closing argument. The state committed prosecutorial misconduct by essentially making a second closing argument instead of a rebuttal argument. Counsel for the state made a second closing argument posed as a rebuttal. So here the argument is, even though the prosecutor is allowed to make a rebuttal argument, but it can't be like a second closing argument. Now, again, is there any sort of case law that they quote here? No, which is always a problem, right? Especially when you're on Brother Counsel's channel. If you're not going to have any sort of cite to some sort of case law about standing up for this proposition, then this argument is without merit. So we're not even going to consider that if I was the judge. Wherefore, premises considered, the defendant seeks the relief sought herein, as well as any other relief to which she may be entitled. The defendant requests a hearing in this manner. Well, that is the motion filed by Sarah Boone. So a motion for a new trial, I think we're kind of expecting some sort of motions to be filed. So a motion for a new trial filed, arguing those specific elements. And of course, that makes my homework a little bit more, because they didn't really do a proper job, I believe, in writing this brief. And therefore, you got to actually go research the law, which I intend on doing, and then reporting back to you. So don't worry about that. I'm going to be doing the hard work, the homework, and then telling you what my opinion is on these different matters that they're bringing up. So that's going to be it for now. If you haven't yet, please subscribe. Please like the video. And remember, tomorrow, 9 a.m., join me tomorrow when I will be live streaming the Karen Reed oral argument in the Massachusetts Supreme Court for this argument of double jeopardy. A very interesting argument, and this can really decide the case. If the Supreme Court decides that she has merit and therefore she cannot be tried again because of double jeopardy, well, there's no retrial at all. So that's going to be a very interesting thing tomorrow. So definitely tune in to Brother Counsel tomorrow, and we will be covering that. So that's going to be it for now. Thank you all for watching, and we will see you next time.